Hi, everybody. My name is Julia Tama, and I'm here with my colleague Chelsea Richmond. We are very excited to get into today's webinar entitled From Privacy Enforcement to Action, Key Lessons Learned from Recent Investigations, both that we have worked on and that we have seen published. It's not a topic that anybody likes to think too much about because none of us wants to have to deal with an investigation, but we're going to kind of approach today from the perspective that an ounce of prevention is worth a pound of cure and try to give everybody some tips that you can think about in advance to try to position your organization as best you can. Before we get into it, I'll just say briefly for anybody who doesn't work with us already, at Venable, we are a full service privacy and data security practice. We do compliance, we do policy. We're well known for our work in ad tech and other areas in particular. And we do a lot of enforcement response, regulatory response, which is what we're going to talk about today. As I mentioned, I'm Julia Tama. I am one of the co-chairs of the practice at Venable. I have been with the firm for 16 years, I think, doing privacy and data security the whole time. And we're so lucky to have many attorneys with us who have also stayed with us for years and years. Chelsea is one of them. And I will let her introduce herself before she gets started talking. For now, let's take a quick look at the agenda of the things that we wanted to cover today. So we've got three main topics. They'll blend into each other a little bit. We wanted to take a look at what are some takeaways from recent enforcement activity, and we're going to focus in that section really on like things you could be doing now to make sure that the organization is compliant in areas that regulators are looking at today. And as I mentioned, that's based on both public things that have been reported and things that we have seen that are non-public, just to kind of stay ahead of the curve a little bit. We'll also talk about what the enforcement outlook might be for 2025. So this is definitely like looking into our crystal ball and speculating a little bit, but just to kind of share some of the tea leaves that we've been reading. And then the last section, we'll talk a bit about what happens if after all these best efforts, you do still get a question from regulators, like what are some immediate things that you can do to respond and position yourself, just in case you do get that proverbial knock on the door. And with that, I'm going to hand it over to Chelsea to say a few words about herself and start us on the first section.
Great. Thanks so much, Julia. Hi, everyone. Welcome today. My name is Chelsea Richmond. I'm counsel in the Privacy and Security Group here at Venable. Today, we're diving into the thrilling, and I do mean thrilling, world of privacy enforcement. Lots of new developments to uncover, some in unexpected areas. We hope to give you some unique insights on key trends, proactive risk strategies, and lessons from recent cases. So with that, we'll dive right into the first slide. Targets. Where are the enforcement activities coming from? So I think sometimes when you receive a CID or a letter, it can feel very personal. Why are they targeting me? Where is this coming from? And we've noticed a few distinct categories that continue to drive enforcement actions. So a few of those we've noticed is one, review of public materials. This has always been the case, and we've definitely noticed it this year as well, reviewing public materials like privacy policies, notices, banners, consumer rights processes, web forms. All of these are open game for regulators to review on your websites and applications and send letters if they deem it necessary. So we continue to see that be a big source of enforcement actions. Another one is industry sweeps. Each year we see different types of industries that are targeted. This year in particular, we'll go through what some of those are, location being one of those. News coverage, this has come up in a couple of different areas, but we noticed it for two very big enforcement actions, that media exposés and write-ups were one driving source. Breach investigations can be another. So reports that come out of breaches or as facts are made public from breach details, this can result in other privacy investigations that maybe weren't the beginning of why regulators were looking at it to begin with. We also see from academic studies or white papers or requests from consumer groups and watchdog groups continue to be another source of enforcement targeting companies. So we'll move to the next. Okay, recent areas of state interest. We're just going to walk you through 5 different areas that we've noticed states are really zeroing in on in the past couple of months, and we think will continue to be an area of focus through 2025. We can jump to the first one. Okay, so privacy policies. You're probably thinking, what new information can you give me about privacy policies? Privacy policies are Privacy 101. We pretty much have privacy policies down by now if you're a corporation who has a functioning privacy program. And we often think of privacy policies as triggering inquiries for misrepresentations or overrepresentations. But this year in particular, privacy policies have been on regulators' radar for some additional reasons. In particular, regulators have indicated that they wanted to see one, relevant state names named in the privacy policy where consumer rights are available. This is a recent item that has come up. Certain regulators have indicated that they don't like to look at privacy policies and see certain states listed and not their state. They're starting to feel a little left out. So what they're doing is part of a GEAR request. Certain states have been asking companies to name that state. Now, the implementation of this can vary, but we wanted to make people aware of this new type of request coming in. Another one is that all available rights must be described in the privacy policy, even if available in only a few states. So similar vein as the first point. And then lastly, consumer rights web forms should be clear and consistent with the privacy policy. This is low-hanging fruit for regulators taking a look at the web form and seeing if this is working properly, if it has all of the rights names, if this is working as it should be. So what to do from this: ensure all publicly available material, including links, policies, web forms, are up to date with current law. Okay, moving now to our second big issue that's come up, which may be a surprise to some people, is cookie banners. And the reason it may be a surprise is US law does not require consent to place cookies, as many of you may know. However, there's been a huge onslaught of nuisance lawsuits that have come up this past year under the state wiretap laws. Some of you may know that the state wiretap laws are telephone laws that have now been applied to tracking technologies online for websites in particular. And this has now come up. Cookie banners have been addressed in 2 CPPA enforcement actions, and we'll walk through what those actions were. But we're now starting to see companies trying to implement certain language on their cookie banners to account for these wiretap lawsuits are now in tension with some of the requirements for the state requirements. Now, the states do not have prescriptive requirements on cookie banners, but where you're seeing cookie banner come up with the states is they're saying, if your cookie banner has this entryway to the rights, so in the preference center, we talk about the advertising rights in particular, right? That now has to be a symmetry. There has to be symmetry of choice there. So you can't have asymmetrical options. So for example, if you have an accept all, you need to have a reject all button. Another one is if you're having okay, or if you're having other types of acceptance, you need to make sure that same symmetry of choice of a reject all is reflected. And we've now seen that in a couple of different states. We had California mention this in 2 different actions with Honda and Todd Snyder. And then we also had Connecticut come out and talk about cookie banner symmetry in one of their reports this past year. So we'll move to the next slide. So some of the key takeaways from all of these enforcement actions was, 1, surfacing the notice. So making sure the banner is unavoidable and it provides meaningful notice. Making sure that you're carefully crafting the language and the choices in the banner, that it is clear and symmetrical, meaning it is easy to opt in out and opt out. This next one is really key: testing to confirm cookie banners are operational, even when a vendor is responsible for implementation. So this came up in the Todd Snyder case where a vendor was effectuating the cookie banners and it wasn't working for 30 days. And what the regulator said was, that's no excuse. You should have been testing it. You should have been on top of it. You can't rely on the vendor solely to do this. You need to make sure that you are responsible for what's going on your website. The next one is reviewing timing of when cookies are firing. This is particularly important for the SEPA state wiretap litigation. So ensuring that the cookies are firing after the consumer makes the choice. disclosing options that must be carefully tailored for the company practices, keeping in mind there's lots of state goals, there's lots of goals for the company, and the goal may vary based on who you are and what industry you're in, whether the SEPA violation is of greater concern, if it's state compliance, how the friction is for your marketing team based on how you present it. So lots of considerations. Not just accepting a vendor's template, as I mentioned, considering all of these different factors that go at play. And then the last one is many companies may be quick to say, well, why don't we just adopt our EU banner? That one is, we've had it around for years. It's very protective. Why don't we just do that? And there's lots of reasons why you don't want to necessarily just adopt the EU banner, right? Full out. There could be friction for the marketing team. There could be, like I said, language that doesn't align with the state compliance and also on the SEPA compliance. So we want to make sure that we carefully tailor it for US considerations. Move to the next. Consumer rights processes. I think everyone's been paying attention to this with the state laws over the past couple years, but just two important points to point out from the recent enforcement actions that have come up in the past couple of months. So both in Honda and Todd Snyder, there were two similar issues, both related to verification. The first was asking for verification on rights that do not require verification. So things like opt-outs. One company required that no matter what type of request it was, you needed to take a picture with your government ID. The regulator said that is not okay. The second is asking for too much information, even on the requests that allow for verification. So in one instance, a company was asking for 8 different points of information when 2 different points would have been sufficient in order to look up the information in their systems. Now, it's going to vary for each company how much information is sufficient in order to look it up, but we just want to point it out that there is a minimization requirement that they're looking for here. We'll move to the next. So key takeaways, as I said, tailor the verification requirements to the different types of rights. Make sure you're double checking. Are we requiring verification where we don't need to be? Are we requesting too much information? And again, looking at what is actually necessary for your company. All right, and now I'm going to turn it over to Julia to talk through some of the location issues.
Great. Thanks, Chelsea. Yeah, so Chelsea walked us through some things that are probably going to be relevant for every company, every organization, right? Some like basic low-hanging fruit that you can take care of. And again, like what we presented was based, Chelsea was emphasizing like the public cases that we've seen, but we are getting that, those points that she covered are also being emphasized in non-public inquiries that we've seen across more states than were listed. So it's really more than what you might see on the surface. Like the cases that you're seeing published and reported are the tip of the iceberg. There are a lot of states out there that are active. Most of them obviously still have cure periods, and we'll touch on that in a moment, but just wanted to emphasize sort of the importance of you can help your company so much by addressing those points that Chelsea went through on those recent slides and like hopefully taking away some potential fodder for inquiries. Location data is not one that will be relevant for everybody, but we really wanted to cover it because it's just been a huge focus for regulators across many states recently. Again, more states than are listed here based on our experience. We know of other states that are reaching out in addition to the things that have been public. They're sending letters, they're demanding responses, like there's a lot of activity here. And the Federal Trade Commission has been active in pursuing location data practices. So this is really kind of an issue that is a high source of risk for any company that's involved with this type of data. We saw in March of this year, California announced an investigative sweep on location data. They pledged to focus on compliance with opt-out requests and right to limit the use of sensitive personal information. And we can say personally, we have seen those letters coming in the market. Like this is not an empty threat on the part of California. Letters are out, they are being sent, and folks are responding. We'll talk in a minute about what to do if you ever get that type of letter. Texas as well, coming online with a new privacy law has been very active actually in a number of areas, but one of them has been location information. The Texas Attorney General's office has brought enforcement involving driver location and driver behavior data. They've brought suits. Those things are working their way through the courts. et cetera. And we also have seen a focus on connected vehicles in this regard. So we've seen interest from regulators at the manufacturer level, with partners, with insurance company, with other types of technologies. But it's not limited to connected vehicles. Location data is obviously used and passed around very widely in ad tech and a number of other types of industries and marketplaces. So this is something to be really aware of if you're touching location data in any way at all. And on the next slide, we'll talk about our takeaways for this area in terms of what we're seeing from the regulator attention. In most cases, companies that are collecting precise location data will need to have consumer consent. And as you may know, there are numerous state laws that are going to explicitly require this. The way that we see the market implementing this is still through the platform controls, where it's something like what you see on the right, where your current location would be displayed, et cetera. Like this is, Apple and Android both have these types of tools that are available. And so, if those are something where that's your consumer interface, that is still the way to provide consent. However, you don't want to rely on boilerplate language for that disclosure that you're using as the basis for the consent either. You definitely want to make sure that the disclosures are clear in terms of what the data is going to be used for, what it's going to be shared for, including advertising, and that you're kind of like what Chelsea was saying about the cookie banners, you want to be adapting these disclosures for your specific use. Sensitive location data is something that has come up quite a bit in the Federal Trade Commission's attention to this issue, with where you see the commission in recent cases pushing companies to have policies restricting, even prohibiting sales of location data that could be more sensitive. So revealing visits to certain locations like specialty medical, religious sites, domestic violence shelters, numerous others. You can kind of do a crosswalk looking at the different cases that have come out. But when we have clients that are working intensely in the area of location data, particularly if they're selling, we really encourage this kind of risk mitigation to kind of think about what places you don't need to be selling and, trying to reduce risk by maybe avoiding certain ones. So that is something that has come up as a theme in a lot of recent cases. Additionally, we see regulators thinking about monitoring your sources of location data. This is something where I would say, industry practices are evolving, but you do generally want to make sure that you have reputable partners and contractual assurances about where the data is coming from if you're not collecting it directly. Then we wanted to just talk a little bit about data broker registration. You might think that this doesn't affect you, but California has been evolving its regulations and has made them quite a bit broader than what we've seen before in the area of data brokers. So for example, where the direction that California is going is if you have any data from a third party that you are passing onward, you could be considered a data broker. So it's really important to consider these laws, even if you don't think, hey, I'm in the information reseller business. We've got 4 states that have these laws up till now: California, Vermont, Oregon, and Texas. And we will add that what we were seeing behind the scenes was that Oregon and Texas, when their laws came online, started to reach out to companies that were registered in other states to say, hey, don't you think you need to register here? And we saw that play out in a number of cases. Our view is that it's really important as an organization to take a look at the laws of each state, because you could be required to register in one and not in others. The definitions are actually quite different. So we do think that this is something that's worth looking at, pretty carefully against your exact practices. And in fact, we can say in a non-public way that we did have, we're aware of companies that, reached back out to some of those inquiries and said, hey, we don't think we're covered, and that seemed to be sufficient. So definitely encourage folks to not just register sort of as the easiest path out, because there can be consequences down the line. In particular, what we see is that registering as a data broker can lead to a lot more consumer rights requests, including from third-party agents. So you can be kind of swamped with these third-party agent requests. That can be very frustrating for your team. And then also what we see is, once you're registered, that can then lead to increased obligations if the state laws start to ratchet up, as they have done in some places, or there can start to be sort of unintended consequences. So, look at the requirements, see if you're covered, but we are not encouraging people to like over register in a sense. And then we wanted to talk a bit about what the enforcement outlook might be for the coming year. As I mentioned, this is kind of us looking in our crystal balls. So we're not 100% sure, of course, what will happen in the rest of 2025, but we have some ideas that we can share kind of based on what we're seeing out there in the world. So one thing to remember is that we do have multiple privacy enforcers in the US. We've got the US Federal Trade Commission. Haven't talked about them so much yet today, but they are, massively important, large agency, very expert. They're still kind of considered active, and we'll talk about that a little bit more in a minute. We also see the US Department of Justice getting into the action, and in particular, we'll spend a few minutes talking about the bulk data rule, so-called, that just came out fairly recently from the National Security Division and really has DOJ getting into kind of the privacy field through the lens of national security. And so we'll talk about that. For the most part, our session today is not focused on like substantive compliance with things, just on flagging issues. But this is one that we wanted to talk about a bit because it's been kind of a surprise to a lot of companies how broadly it reaches. Then, of course, we have the states. And so for most of the states, it's with the state attorneys general who have the authority to enforce the state consumer privacy laws. Also, in many cases, they have authority to enforce federal privacy laws. So, like the Children's Online Privacy Protection Act, that can be enforced as well by state attorneys general. And many of the state attorneys general have been super active on privacy. It's been that way for a lot of years, but it's certainly continuing. And an interesting dynamic that we're seeing now is as the Federal Trade Commission under new Republican leadership might shift its priorities, might shift its activity level in certain areas, we do expect that we will see state attorneys general kind of stepping in to continue to carry the banner of privacy enforcement, regardless of what the Federal Trade Commission does. I don't want to say like stepping into the gap because I don't, we're not expecting the Federal Trade Commission to like cede the field at all. But we do expect the state attorneys general to be very, very active in this coming year and beyond. Again, really, regardless of what the Trade Commission does. And then in California, of course, uniquely, in addition to the state attorney general, they also have the California Privacy Protection Agency, which is doing rulemakings, but also enforcement, particularly on the data broker front, interestingly. So we've seen a lot of activity out of California. And just want to emphasize also privacy really truly is a bipartisan issue at this point. So you could have a Republican attorney general, you could have a Democratic attorney general, you could have different leadership at the Federal Trade Commission. Privacy enforcement is not going away regardless. So just something to be aware of and to sort of help keep this as a priority at your organization. I'm going to pause right now and give the CLE code for anybody who is doing CLE credit on our session today. The CLE code is Action 2025. Again, that's Action 2025, and I'll repeat it again at the end. Okay, so we talked a little bit on the last slide about multiple privacy enforcers. One important element of that is that different agencies can collaborate and come together on joint enforcement actions. This is something that we've been foreseeing as a possibility since the states passed their state privacy laws, and it's really starting to come to fruition now. Most recently, we saw 7 states form a bipartisan coalition to collaborate on privacy enforcement. So it included both of the agencies that I mentioned for California, and then also some other states that have been very active, some of which are sort of behind these non-public inquiries that I've mentioned, or have been active in issuing guidance, or have done rulemakings, et cetera. So I think the list of states is not so surprising, but it is interesting that they've come out openly to say, hey, we are signing a memorandum of understanding. We are going to, talk about these enforcement cases. We may bring cases together. We are going to try to align on how we handle certain things, particularly the elements that are common across the states. In some ways, consistency could be a little bit helpful, but mostly it's a little bit concerning from the perspective of a target company, that you could have, instead of one state coming after you and seeking the fines for one state, that you could have multiple states. And so, especially as the cure periods start to wear off in these states and they begin to pursue enforcement quite even more aggressively and be able to obtain fines and penalties, it really ratchets up the level of risk from these laws. We can go to the next slide. I mentioned that we still have the Federal Trade Commission. Of course we do. Currently, the FTC has 3 Republican commissioners. The 2 Democratic commissioners were removed from office a little while back after President Trump um, took the White House. That's kind of working its way through the court. But in the meantime, we have 3 sitting Republican commissioners, and they have 3 votes, and they are, well able to bring action on behalf of the commission. We do expect that they'll continue to bring privacy enforcement action. I mentioned it's bipartisan, it's perennial. They're going to continue to do more. We do think the priorities and theories will be a bit different from those of the prior commission. The current chair, Andrew Ferguson, has pledged that enforcement actions will not be used as a substitute for federal privacy legislation. And we kind of take that to mean that, more novel theories may not be pursued as much under this commission, but we still expect them to be very vigorous in their enforcement. And the areas that they've signaled that should be watched include data transfers to foreign adversary countries. So I mentioned the bulk data rule a couple minutes ago. The Federal Trade Commission enforces a statute that is similar in its scope and reach, but definitely not identical, called the Protecting Americans' Data from Foreign Adversaries Act. And that was actually passed about a year ago. As far as we know, publicly, the Federal Trade Commission had not done much with it, but the current leadership has signaled and commissioners have signaled that they are going to be looking at this area very closely. So along with the bulk data rule, which I'll talk about in a moment, this is an area for companies to start sitting up and taking notice. Also, children's privacy, which is a very bipartisan issue and has long been so. We expect that this commission will be active on it, and they've been quite vocal about content moderation as well. They just put out a request for information from the public that I believe closed last week, where comments were coming in. So that's not specifically a privacy issue, but it's a tech issue. So these are all areas where we expect the current commission to be active, and ones where you're going to want to kind of be attentive to what your organization's practices are and whether they're compliant, because you don't want to become a target. On that front, I'll spend on the next slide a couple minutes talking about kids' privacy. Just as a flag, the Federal Trade Commission recently finalized an updated children's online privacy protection rule. We're not going to try to cover substance today. The changes were relatively minor, but there were some new obligations. And here we do think that continued active enforcement is likely, as I mentioned, in part because of the money penalties that are available under the law. So the Trade Commission and state attorneys general always like to go after COPPA if they can, if they have a basis for it, because of the money penalties. So this is something that's always going to be an area of concern if your organization has any involvement. And one thing we really like to flag for companies is if you are asking for birth date at all, even if you think you're asking for it for like a surprise and delight birthday promotion, or if you think you're asking for it to like get agreement to your online terms, any place you ask for a birth date can become a source of risk because you may have knowledge that you have kids or teens on the site. So it's just an area to be very, very careful, because if you don't think of yourself in the area of kids, you may not realize that your business is actually collecting this, and there can be a whole chain of consequences from it. So we could do a whole webinar on that, and in fact we have, but I'll just mention that very briefly. We also are seeing interest in regulating privacy in more ways, both in Congress and in states. Plenty of state laws coming online or trying to come online related to child and teen privacy. Some of them have suffered setbacks in the courts. So if this is an area of interest to you, you do want to kind of stay up to date on how the courts are handling some of these so-called kids code laws in the various states. But to the extent that the laws are enforced and have not been set back by courts, we would expect those to be very active areas of enforcement as well, because it's just such a great headline if you're a regulator, you're an enforcer, to be talking about protecting kids. And I mentioned, that we wanted to highlight for folks this DOJ bulk data rule. This is an interesting one. We're by no means going to try to explain how to comply with this today. That's another whole webinar. But this was an interesting one because I think early on in the Trump administration, the rule was issued kind of in the waning days of the Biden administration. And so there was some kind of discussion of like, is the current administration, is the current DOJ going to enforce this rule very actively, or will it kind of sit on the books? Now we've seen enough coming out of the National Security Division that we can say this is going to be actively enforced, or at least they are signaling that it will be actively enforced and that they expect companies to comply. So a bunch of guidance was issued a few weeks ago explaining more about how to comply with this very complex and lengthy rule, and also providing a 90-day pause on enforcement until July 8th for those engaged in good faith efforts to comply, which signals strongly that after July 8th, they will be looking to enforce it and they will be pursuing these types of violations, which is tough because it's a as I mentioned, a complicated law, and it has a lot regulation rather, and it has a lot of operational impacts for many companies. So it's going to prohibit certain bulk data transactions with a nexus to any one of 6 countries of concern: China, Cuba, Iran, North Korea, Russia, and Venezuela. Often China and Russia may be specifically difficult for a lot of companies because there's a lot of legitimate business that goes back and forth between China and Russia as well. And one of the challenging parts of this rule is that the threshold for what is bulk, or what is considered covered by the law, is relatively low. And so, in fact, a lot of routine advertising transactions and other kinds of transactions that a company might do constantly can be covered. So there's a need to kind of go out and review, customer relationships, vendor relationships, and things like that, and see if they're covered. With regard to vendors, employment, and investment, those transactions with those countries can still be allowed, but there's a lot more diligence that you'd have to do it. So again, don't want to go too deep into the weeds on this one, but we really wanted to highlight it because it has not been on a lot of companies' radars, or a lot of companies were kind of, again, hoping that it would not be enforced until farther down the line. And that's not what we're seeing. Based on the signals that we're kind of getting out of DOJ, we would expect this to be pretty actively enforced, starting in July, and would encourage companies who might be covered to have at least, be starting to put your compliance in place and be starting to do kind of as much as you can to show that you're engaging on it. And with that, I will pass it over to Chelsea to say a few more words about what we're expecting on consumer privacy laws, building on what she shared before.
Thanks, Julia. So 2 more sections we wanted to go through, looking at enforcement ahead, and then we'll end on some tips for if you get a CID or other inquiry from a regulator. Looking ahead at state consumer privacy laws, we wanted to highlight a couple of states that are really active on this front. Some are the usual suspects, but we have some dark horses coming up. California, of course, is continuing to issue new regulations, specifically with the automated decision-making technology as of recent. We're also seeing both the CPPA and the Attorney General routinely follow up on consumer complaints, launch inquiries, and bring enforcement. We do not suspect any slowing down from California at this point. Oregon is one that we have been seeing more activity on. Cure periods apply, but the Department of Justice is reviewing privacy policies to make sure Oregon rights are covered and following up on consumer complaints. We've also noticed that that state has been following up on data broker registration requirements, so just to be alerted of that. Texas, another usual suspect. We're seeing the Department of Justice be very active on that front. Julia mentioned some of the lawsuits earlier in the presentation, specifically the ones filed in connection with alleged sales of geolocation data. We're also seeing Texas continue the trend of following up on data broker registration requirements. Another dark horse that we're seeing come up is Delaware. Again, a cure period applies, but we're seeing lots of activity on reviewing privacy policies, sending inquiry letters to companies. Connecticut as well, a similar approach. We're seeing much more activity. As I mentioned, they released a report some weeks ago talking about what they were able to accomplish and then some of their priorities moving forward. So we suspect Connecticut will be very active as well. Cure periods. So we've had this great thing of cure periods in some of the states so far, but we just wanted to remind everyone that there are sunsets coming up on these cure periods as we move forward. California and Colorado. Colorado was January, and then looking ahead, I want to call out Montana because this is a recent update. There was a law recently passed where the original expiration was April of 2026, but under the new update to the law that passed, it is now going to be October 2025. So if you had calendared this for later next year, just be aware that this has now moved up in the deadline. And then also flagging some other states, Delaware, New Hampshire, Oregon, and Minnesota will be following shortly after. Now, there is still the option for the Attorney General to offer the cure period in some of these states, but it could be at their discretion, so you can't always count on this to be the case.
And I'll just jump in there, Chelsea, to say that I wanted to add on that front that we have experienced with some of those states with the discretionary cure period, California in particular, that it does not seem like they are offering it for the most part. So folks should not have any false sense of security, as Chelsea said, that, oh, we might get that discretionary cure period. That's kind of not what we're actually seeing in the market. And I think I would just add that like some of these states that we see here with the cure period expirations coming up relatively close, like correspond to the states that we're seeing being very active on inquiries right now, which is fascinating because it seems like they're kind of using this time period to learn more about business practices and kind of start to get some voluntary compliance under the cure period provisions, and then be able to really come in sort of more strongly, I would think, with enforcement when those cure periods expire. That's just my speculation, but it's sort of based on what we've been seeing behind the scenes.
Move to the next. Similarly, reminder of some of the timelines coming up for universal opt-out mechanisms. So universal opt-out mechanisms, or the UOOMs, as we like to call them, allows users to signal a single browser level privacy preference. So for example, the do not sell or share my personal information link. It's required under certain state laws, not all state laws. California and Colorado were some of the first states to implement them, like the global privacy control. You'll hear the GPC referred to often. These signals must be treated like any other valid opt-out requests. So even if users do not visit your privacy center, it must be recognized. So an example is if a user visits your site with GPC enabled, they don't need to click anything. You still must honor their signal under the state laws. So some of the ways you can get ready for this, if you haven't already, make sure you understand if your site is ready to detect and respond to these signals, making sure internal teams are aligned on state-by-state requirements, and understanding how it affects vendors as well. And your ad tech stack must represent GPC signals as well. So moving on. Okay, so this is our final portion of the presentation. We're going to go through what to do if you get those fun letters in the mail responding to regulators. So we can move to the first one, preparing in advance. So making sure any regulatory inquiry will reach the right team quickly. Regulators do not like being ghosted. Delays in responding can escalate inquiries or also trigger fines. One tip you can use to help streamline this process is to create a central privacy inbox monitored by a trained team, make it easy for regulators to know who to contact. Also, setting internal response timelines for routing and response can be helpful. You can also add automation for flagging regulator-related keywords or certain email address for inbound requests to make sure that these requests make it to the right people. Knowing what laws apply to your organization and taking advantage of exceptions. Know that not every law applies to every entity or every data set for that matter. So maintaining a jurisdictional data map, legal matrix that identifies applicable laws by region, product, or even customer segment can be really helpful. The tip here is understanding the exceptions, whether it's insurance, it's HIPAA data, it's employee data, B2B carve-outs, public data exclusions, and documenting how you are applying those exceptions to your data sets. Confirming and documenting compliance. So if you didn't document it, some regulators can say it didn't happen. Developing a regular cadence of privacy audits with logs, checklists, sign-offs, using compliance dashboards to track key privacy milestones, if that's helpful. Having comprehensive risk assessments. So you can't mitigate what you don't measure. So making sure you're building the privacy risk register that brings data processing activities by risk, and you're incorporating both the business impact and the likelihood of misuse or breach when prioritizing. The red team review, I want to especially flag because this has been something that's been incredibly helpful for companies, is really taking a hard skeptical look at how a regulator or even a skeptical customer would look at your website, your application, any type of interaction with your business. And this can be done through outside counsel or an internal cross-functional team to conduct reviews of the website and applications, doing a full review of notices, cookie banners, consumer right tools, web forms, not only looking for, do I have everything in place that complies with all of these state laws, but are they functioning the way they should? Is it effectuating it the way I need it to work? Is it even working in the first place? Like we talked about earlier with Todd Snyder, they had a whole month of the opt-out request not working, and ultimately that landed them a very big fine. So making sure that you're doing these secret shopper reviews and assessments can go a long way. Vendor and third-party risk assessments. So your data risk is only as strong as your weakest processor. Inventorying all vendors handling your personal data, assigning risk scores. It can be based on volume, sensitivity, geography. There's lots of ways to do this. We can help you do it. Requiring privacy due diligence questionnaires, checking on vendors, for breach history, compliance certifications, what type of companies have they worked with in the past. So making sure you actually have due diligence in place. This is especially important in light of the DOJ bulk data rule Julia mentioned earlier, understanding where those vendors are located and where the data is going to. Security risk assessments. Privacy and security are married and divorce is expensive. So collaborating with the InfoSec team to ensure personal data is part of your security risk assessments, and that privacy risk are being tracked alongside the cyber risk as well. And I want to flag that for those of you that are under the New York DFS jurisdiction, we have some new requirements that have come out this year, looking at some of the multi-factor authentication requirements that are going to apply in the fall. So there is some privacy implications working with the cyber team and making sure that all of those requirements are met. And then the last one I'll mention is white papers for outside audiences. This we find to be an incredibly helpful tool, not only for regulators, but outside stakeholders. Transparency builds trust. So creating plain language summaries of your privacy program for different audiences like sales teams, customers, and partners can go a long way. Julia has some more tips.
Yep. So the last couple slides, we just wanted to cover a little bit kind of the immediate aftermath of what happens if you get an inquiry letter or a civil investigative demand. I sincerely hope that does not happen to any of you on this webinar, especially because many of you are our clients. But if you do, it's good to have a little bit of a sense of what might happen next. So first of all, don't panic. There can be a sense, as Chelsea said, of this is very personal and we haven't done anything. And, what do we do now? And this is sort of an attack on our way of life. And, it can definitely feel like that. We always, understand that this is a very difficult moment for any company that has received this type of inquiry. But the inquiry is a long road. It's a long path from just getting that letter into seeing what happens next and, reaching the end of the line, whatever that is, whether it's a non-public closure or whether it's a public settlement. And, we handle these types of cases and inquiries all the time. Most are concluded without enforcement action. And if you have done your diligence work, you're going to be in a better position, of course, to have that inquiry closed without any action where you're able to just explain yourself yourself whatever misunderstanding there was and like get the company out of it. And that's always the outcome that we hope for. And again, many, many times that it happens. So, in the immediate aftermath, you're going to want to make sure that management and the board is aware of what is happening because it is sort of a big deal to be getting an inquiry. But you also want to make sure that they understand that an inquiry is not an enforcement action yet, right? It is the beginning of an investigation where a regulator is kind of feeling it out and kicking the tires to see whether they do think there was a violation of law. So it will sound very scary when you get the letter, but it's good to make sure that management and board understand that this is honestly kind of a cost of doing business today. So many big and small companies have gotten these. It may come to nothing. We need to take it seriously, but there's a long road to go. You do want to typically notify your insurance. Usually they may cover it, they may not, depends, but usually they have a requirement to notify. And the only way that they will cover it is if you notify. Like if you don't notify, you're definitely not going to get coverage. So usually, we review these types of insurance policies all the time for clients who have gotten inquiries, but usually the answer is you should notify. And you don't want to delay to do that because there are often certain requirements around that. So that's something to just bear in mind. And then also, of course, you're going to want to issue a legal hold right away. And if we go to the next slide, we wanted to talk a little bit about some of sort of the complexities of a legal hold in like a privacy type scenario where it may actually be on a later slide. So anyway, we'll stay on this one. But in a privacy type scenario, you want to be very careful with the legal hold because there can be complexities related to like technical data and, logs and things that may be rolling off. So I'll return to that in a moment. When you talk to the regulator, one of the first things you're going to do after getting the inquiry is reach out and start that dialogue with the regulator. If you are in-house counsel, if you are a business, if you are engineering, you're probably not going to be doing that yourself. We don't really suggest it. It's best to engage through outside counsel. Ideally, counsel that handles this type of case all the time and has the relationships where you need to have it. Is a relationship going to get you out? No, but it is going to make the dialogue more productive. And you want to have somebody who's sort of a frequent flyer at the agencies and kind of knows how it works. Regulatory defense is not litigation, and so we do find again and again that it's helpful to cultivate goodwill, put your best foot forward, and kind of get that dialogue going. Again, it doesn't mean that a regulator is going to look the other way if they think that they see a violation, but it will best position the company to be a trusted narrator of its own practices and to be able to interact with the regulators in the way that they like and the way that they are used to. So beginning that dialogue promptly is really helpful. Like we've heard, from regulators sometimes that, as Chelsea said, that there are companies that don't even respond. That is not a good way to start out, down the path of having the inquiry. You can try to see if you can feel out the reasons for the inquiry, which can be good to know. Is it part of a sweep? Was there something that was maybe put out in the media about your organization that may not be accurate? Is there some kind of misunderstanding that you can clear up right up front? That can go a long way towards getting things back on the right footing. It won't necessarily make it go away, but there can definitely be cases where regulators, because they're viewing from the outside, they may have a fundamental misunderstanding about the business or how it operates. And so clearing that up as early as possible is super helpful. It's very routine to negotiate a rolling production. So again, don't freak out when you see that like 2-week turnaround in the inquiry. You, again, just kind of want to get counsel on the case and figure out what your actual timeline is. And if you want to get that rolling production, you're going to have to show that you're operating in good faith, that you're doing the best you can, that you're offering something that's reasonable. So that's another reason why it's important to kind of get that productive dialogue going, because that's the way that you can sort of work this out in the means that's like least burdensome for the organization. Likewise, you can narrow the response to what's reasonable. And this is all stuff that, an experienced counsel is going to be able to handle for you. And just kind of good to know as you're thinking about like, oh, what happens next? What will this look like? This can typically, if you're starting off on the right foot, typically you can negotiate all of this into something that is manageable for the company. Again, you may have to show why it's reasonable, that none of this is sort of an easy path, but it is something that is routinely offered in terms of being able to get that rolling production when you demonstrate the need. And then on the next slide, we did want to highlight some things that we have seen as common pitfalls in responding to regulators kind of early on. As I mentioned, there can be a lot of misunderstandings when a government agency is looking at your business from the outside. Maybe they've read about it in the media, maybe they're seeing something in an academic study, maybe they are looking at data transfers, right, that they think are happening. They're looking at maybe an SDK or something where they think they see data being transmitted out. A lot of these agencies do technical reviews as a basis for bringing an inquiry. It is very helpful if you start out early explaining the business model, to the extent that it's relevant, explaining things that are technical terms. Don't assume that the regulators have the same understanding of a technical term as you do. You just want to kind of have it be upfront. We're not suggesting to offer a bunch of unnecessary, not required information, but just to make sure that everybody is aligned on what words mean or what your actual business is. That can be really important, and you can avoid a lot of mischief by doing that early on. You can also be creative. Again, it's not civil litigation, really. A lot of this is a bit different and it operates differently, right? So you can think of compelling ways to present crucial information. Maybe a white paper makes sense. Maybe a consumer survey can help demonstrate that something was not misleading. Maybe there's an expert from within the company or outside the company that can help explain something that might otherwise be misunderstood. So these are all options that can kind of be worked out with the agency if they're open to receiving information in certain kinds of ways. I mentioned the legal hold. A couple of things that we're running into recently is as companies increasingly move to Slack and other types of messaging platforms, those are communications. So you need to look into sort of what your retention policies on that and make sure that you're not losing things that need to be under a legal hold. Terminated employees are always an issue. If somebody has left who is a relative, an important sort of record holder and they left like a week ago, you want to hang on to that laptop. Don't let it roll off. And then automated deletion schedules are something that for like privacy investigations end up being really important because a lot of times the underlying raw data might be something that's viewed by the enforcement agency as important, like logs, ad requests, things like that. But they're also massive to hold on to. And so most companies are going to have an automated roll off in place. And that's something that you have to negotiate with that if it's potentially relevant and potentially should be under a legal hold. Typically you want to start negotiating that early with the agency and make sure that you're not going to get in trouble later for stuff having rolled off. And there's often like an opening there where you can kind of negotiate what will be kept into something that's reasonable, but it's all got to be determined based on what you have your facts at the time. Regulators are often, and I think increasingly, privacy regulators are very informed about tech, and they often have technical folks on the staff that they're talking to, but the perspective can be different. And so time and time again, we notice we do need to explain very carefully what the practices are from the business perspective and what is feasible. Because sometimes the technical folks on the government side will be saying, well, you can do X and Y, but there's a business reason why you really can't. And so communicating about those things, takes practice and skill. And for our last slide, we'll take questions if we haven't gotten them already. And I know we're a little bit before the end of the hour, but hopefully that is welcome for everybody. You can take a minute. If you don't have a question, you can sign off and take a minute before your next call. And if you do have a question, feel free to put it in the chat and we'll help answer. And I just will close by saying thank you so much to everybody for spending the hour with us. I hope you can see that this is a topic for which Chelsea and I have a lot of passion and interest, and we're happy to have been able to share it with you. For those who are on the call, just mentioned we got an interesting question from the group in terms of what should an organization prioritize if its internal resources are limited to ensure it's maintaining compliance nationwide? That's such a great question. I see two aspects of this. One is just what to prioritize generally. And I think Chelsea's presentation at the start of our webinar is our checklist of what we're suggesting that companies prioritize right now. Make sure privacy policies are correct and that they are doing what regulators actually want them to do. Naming all the states that offer rights, for example. Make sure your cookie banners are really carefully crafted. Make sure that your consumer rights processes are clear and easy and working the way that they should be. So that's one way to prioritize is just those outward facing things that are so easy for an enforcer to pick off. The second answer in terms of prioritizing is what do we do with all these kind of varying standards, right, across the many states? And so, obviously the gold standard is if you can offer the very specific things that each different state, requires and kind of do state by state. But we understand it's really not feasible for a lot of companies. And so, at that point, what you're going to want to do is kind of focus on the things that are core and common across the states, right? Make sure you have your access request process working well. Make sure you have your deletion working well. Make sure you have your opt-outs, et cetera. And a lot of that can be done in a way that's consistent across the states, maybe like 90% of it, and then the other 10% will be different by states. And you can see if there's things that you can do with that 10% that sort of offer some of that state by state, but without actual work, like, without more back end work. So for example, you could offer the ability to do the special consumer rights in Oregon without too much actual back end work that's tailored to that, hopefully. So those are some ways to kind of start to be a little bit more uniform. I also want to mention once again the CLE code for anybody who might have missed it. It's Action 2025. Action 2025. And we got some questions here just in our final moments about cookie banners in terms of creating symmetry where the cookie banner is a notice only. And then another question was, is symmetry required if you are clear that the banner is not taking the place of a privacy right, such as an opt-out? I'm going to give a non-answer here, and I apologize to the person or people who asked these questions. It is so challenging to do cookie banners right now because of these cross-cutting dynamics that Chelsea mentioned. We have state privacy laws. We have enforcers from the states saying, hey, this is necessarily, something that you're offering to fulfill state privacy rights. You are trying to avoid lawsuits under the wiretap laws. The theories under those cases are changing all the time. You are trying to meet industry self-regulatory standards potentially also with that banner. And by the way, you're working with a bunch of vendors who designed their banners for GDPR and did not design them for the US. Frankly, I don't think we've seen like anything that's sort of 100% of the way there for the US yet. So symmetry is a basic one. We do, because that's very clear message from those cases that Chelsea mentioned, right? Accept all, reject all. And then in terms of what does it say above that, like what's your disclosure, it will depend very much on your risk tolerance, the specific things that are concerning you, and how it plays with your privacy policy and your web form. So I'm sorry to be vague on that, but the reality is that we are drafting those in a very bespoke way right now, depending on how companies handle a bunch of different things. We got a final question on balancing legal retention holds and honoring opt-outs. If you have a legal retention hold, typically you're going to be able to keep that data under an exception. So you would not want to run afoul of a legal hold due to honoring opt-outs. That's if it's more complicated than that, it would be something you'd have to look at case by case. But typically we would say that a legal hold would override an opt-out. And I believe that brings us to time. So thanks for all the great questions at the end. Really appreciate it and really appreciate everyone's time. Thank you.